Hello and welcome to the Daily Lawyer podcast. My name is Jenna Krishnan. I'm your host and the founder of the Daily Lawyer. And today we continue our legacy series, which is in collaboration with one of India's oldest and most respected law firms. I'm speaking about Messrs. Solomon and Company, whose legacy has continued across 4 generations and 115 years. I'm so honored to partner, to collaborate with a firm that truly stands for the values that we are attempting to bring out through this series. The Legacy series is a shared mission. It's a heartfelt mission of ours to preserve the wisdom, the stories, the contributions of giants to the Indian legal system. We seek to create a historical archive of conversations that any one of us can dip into, to take inspiration from, to learn from. And with that in mind, I am so excited to introduce my guest for today, Mr. Justice Gautam Patel. So, welcome to the Daily Lawyer.
Thank you so much, Jenna.
Podcast Legacy series, which you're doing in collaboration with
Thank
Solomon
you.
and Company.
Thank you.
Justice Patel is a retired judge of the Bombay High Court. He started his practice in Bombay in 1987, and his practice was mostly spanned across constitutional law, civil law, commercial law, but he's very well known in his advocate days for advocacy in environmental matters, in public interest litigations, whether it was the Coastal Road Project or mangrove conservation. He was also the secretary of the Bombay Bar Association for 2 consecutive 3-year terms from 1999 to 2005, and then he served as a standing committee member on the association till his elevation to the bench. He was a columnist in Mumbai Mirror, and I think he's very well known for that. He's actually one of the most popular jurists, I think, of our High Court in the recent times, because you're known for a lot of things, but I think your writing style is something that all of us know and enjoy and have enjoyed. So I'm very, very excited for this conversation, and you will know why as we go in. So thank you again. So we will start. Actually, I want to know, and I'm sure the audience wants to know, if you can take us back to your journey into the law. Like, why did you decide to pursue the law? How was it? Just take us through the arc of your journey so far.
There wasn't a journey into law. It was the sheerest accident.
Is it?
I stumbled into it. I wasn't planning to do law at all. At the time, I had graduated with a degree in economics and mathematics, and my interest wasn't in anything to do with the law. It was to do with cinema.
Wow, okay.
So I had gone and got myself applied to FTII and stuff like this. And I was watching 10 films a day at various clubs, all kinds of neorealist cinema and stuff like this. And it was the surest accident when a friend said, let's go to this place called Law College. They've got something called a moot court on. So my first exposure to law. I mean, we had friends in the family who were lawyers, but no real exposure to the law in that sense. And I saw this moot court thing happening at Government Law College, and I think that was it. I decided that's what I wanted to do. I had no idea what it involved. It just looked very exciting. So that was it. Literally, that's the whole of the journey.
So that's the whole of the journey. I loved it.
So,
This is like no, but then so you enrolled in GLC, Government Law College, and then you just.
well, I enrolled in GLC, but a few days before I enrolled in GLC, because there was a close friend of the family who was a solicitor, he said, why don't you should come and work in the office and see how it's done. So I started working there long before I had a degree, long before I was even in law college. And then sheer luck, I think, because the very first few pro bono environmental law cases came to him, and he was too busy, so he said, you've got to handle them. And it was tough. So, but, then we had this big team, Atul Setalvad and Navroz Sirvai and all the rest of that, Rajni Iyer and all those. So we got going on those cases, and that was a great learning experience because beyond the classroom, you got to actually deal with cases that were going live in court in very, very short times. The turnaround time was really quite tight. So I got a first-hand exposure there very early on in the game, which was a great advantage. So that was how that really began. So those years took me through to graduation. And then I decided I wasn't going to do a practice as a solicitor, and I wanted counsel practice. So first joined Iqbal Chagla and then Janak Dwarkadas a short while later. It was Janak's first junior. And that was a great learning experience as well. Because Janak wasn't then on the senior list. He wasn't, he wasn't where he is now, still doing a lot of drafting at that time, mad amounts of work going through the chamber and stuff like this. So it was a great learning experience because you got exposure to a very wide variety of cases back in the day as well, and very supportive. So that was the beginning of it. So the rest then I think followed.
So then, yeah, so I think we are going to the rest that followed, because your time before you ascended the bench, you had a very good practice as a lawyer, and you were quite known in the, especially in environmental law. I know that when we also briefed you once was for an environmental law matter, but advocacy in whether it is mangrove conservation or the coastal road project with BEAG, I think that was
No, the coastal road project is much recent.
yeah,
Later.
yeah, that was one.
No, it was the Worldly Banner ceiling thing that we did.
The ceiling thing, that's right. But then, can you take us through that? How was it to?
Well, so because in the early days I was associated with the Bombay Environmental Action Group and we'd
Correct.
done all these PIs.
Yeah.
So that continued and that actually grew because now I was doing the drafting myself and I was able to appear in all kinds of matters. So we had wildlife matters about game sanctuaries, we had urban issues, we had a whole range of issues that we were dealing with, everything from conservation of heritage listed buildings and the
Correct.
drafting of that statute and that regulation to the coastal regulation zone, which was an important aspect of this, all the way into tiger and wildlife conservation. So we were doing a huge range of stuff. Illegal constructions in Mumbai, illegal constructions in Pune. So it was taking up a lot of time. Plus there was other regular commercial work, bank suits, commercial litigations, writ petitions and stuff like this. So that was going on. It was a busy time. It was a busy time. And there was a lot of drafting. There was a lot of drafting then.
And how was this whole, how was when you served as a secretary of the Bombay Bar Association, and how was all of that? How did that
came
add to
much
your career?
later. Did it affect my career? No, not
I
really.
mean add.
That came much later, and I thought it was important to do because it was some form of giving back to the association, of which I'd been a member for a
Yeah.
very long time, and then I was able to, fortunately, because of the support that I had from colleagues and friends, start making changes at that time, which people had resisted. I mean, we had got an online presence. We just streamlined functions and operations, got things going in a little more systematic manner and stuff like this, rather than carrying on as we were. And it worked quite well. It was a lot of hard work. It took a lot of time. It took its toll as well. And then we did that big project on the 150 years of completion of 125 years of completion of the High Court building, which was a big grand affair. With the book, that first coffee table book that came out at that time. So that went off.
2005, is it?
About that.
Yeah,
a little.
no? Right.
So that went off, no, earlier.
Earlier,
So that went off, very well. Those were great years. And then the practice was continuing in any case. So that was about, 7, 8 years before judgeship. So
Yeah.
there was a long period in between.
Yeah.
And I was doing by then a fair amount of work in arbitration as well, which was good because that was another dimension to the law that I got to explore. And somewhere in between, I got this opportunity to do this weekly column for the Mumbai Mirror, which was great and was quite influential for later years because there was the discipline of having to do an 800, 900 word piece week after week
Yes.
on a fresh topic researched,
Yes.
which was a kind of discipline and a training. This was, I think, very, very good for the years that followed on the bench. But the years at the bar were, I think, coming back to that, were very interesting because of the sheer range of issues that you got to deal with and the kind of people that you got to work with, both on this side, that side, all the rest of this between Bombay and Delhi. It was really quite fantastic. The whole thing was fascinating.
Yeah.
The whole thing was fascinating.
But I think I remember having a conversation with you. I don't know whether you recall this, but you'd written an article on the state of potholes in Bombay on Mumbai Mirror. And it was a very, very well written article because It was also very funny. The way you treated it was very funny. So we were all sitting and I told you, I really loved your article. And you said, yeah, I had to do so much of research to get to that article. And I don't think I realized, because it seems very effortless, when you read it.
Yeah,
It
but
doesn't seem...
when you've got something that looks effortless, that's a lot of effort that's gone into making
I
it look
know.
effortless.
So now
Every single time.
I see how it was training for the later years in the bench, and you've given me
Yeah.
a perfect segue to ask you about your time at the bench. First of all, before that, why did you decide to take up judgeship? Because you were having this wonderful career as a lawyer.
Actually, don't know. Okay, so was I dying to do it? No. Was I willing to do it? Yes. Difference between the two. And I wasn't terribly fascinated, never was, about the label or the position or whatever it is. It just seemed to me, watching them for over the years, that this was a fairly intricate, difficult, and challenging kind of job, very different from what we were doing as lawyers. As lawyers, you are doing justice to your own brief to your client, but as a judge, he's got she's got these two sides and has got to find some solution
Yeah.
to what appears to be a problem. It's problem solving.
Yeah.
And you really have to navigate through this, which is a interesting task. And I wasn't entranced by any of these notions that, I'll do some great good for society. Nothing of that kind. It's a job, it's a salary job, it's a government job, but you have to really get out there and do the job as best as you can. But the attraction for me and the challenge for me was, how do you solve the problem in the best and most efficient way that you know? That seemed to me something that I would get interested in. The scary part about accepting judgeship is that there's no plan B, there's no exit. Means you're committed to this, and you have to see it through. So that's the thing that really makes you pull up short and then ask yourself, are you really going to do this? Because you have to stay the course.
Yeah, true.
You have to stay the course.
Yeah, you can't throw in the towel,
You can't chuck in the towel. So,
that's true. I don't think that is something that's
people don't
we
realize
say,
that you really have to be there prepared to
Yes.
see this one through. And that's a commitment that you're making for the rest of that tenure, or 10 years, 12 years, 15 years, whatever it is, without an exit option. It's irreversible. Plus, you don't have a choice about the work that you do, and you don't have a choice about who you work with. These are the liberties you have as a lawyer. These are freedoms that are taken away from you when you become a judge.
Wow.
Which is something you have to be prepared for. Absolutely.
That's something we've never thought of. Actually,
But people don't, and
Yeah.
and it's a mistake to get fascinated with the idea that one is a judge, or that because one is now a judge, therefore suddenly life is to be different. Nobody really cares that you're a judge. They only care about what you do as a judge,
correct.
not the fact that you are a judge. The label doesn't make any difference. If you're going to squander your time with meaningless fripperies because you're a judge, nobody really cares. It's what you're actually able to do with the work that comes your way that really matters. And that's the real test in that bargain.
Sir, I think I read something that, I don't know, you were giving a lecture recently, and you said that people or lawyers must consider the offer of judgeship seriously.
I did say that.
Sometime recently. Now, the reason why what I'm asking very specifically is, there is a lot of misunderstanding about the work of a judge in the minds of common people. They don't, they probably think, because maybe thanks to Bollywood or whatever, they think the purpose of a judge is just to bang the gavel and, say order or something like that.
We don't even have a gavel.
Exactly. Correct.
I don't think I ever saw a gavel in India.
I know. So, I want to clear out this misunderstanding, and we've spoken with Justice Sridevan of the Madras High Court, with Justice Sri Krishna, then with you. But I think we have to keep saying this because, and I'm going to give you a small insight as to why I'm saying this. We were in the Bombay High Court. My father had a personal matter, and it was a bad day, and he was completely down in the dumps, and I was sitting with him, and you had written a judgment on that Madras cafe or some cafe here, not Madras,
Well,
Devi cafe or something. There's some cafe here in town.
Dwarka.
Dwarka. And
That was fairly recent.
yeah, recent. Yeah, this was a recent incident. And the way you written the judgment was hilarious. So I got it on one of the groups and I showed my dad and I said, look, Pal. So he started laughing. You know, he's a big PG Woodhouse fan, so he really enjoyed what you wrote. And he said, oh, okay, so I feel happy that judges are like this, like they are not. And I said, this judge is in this court, okay, nothing's going to happen to you. He's like, oh, I feel happy. And then, after
You're
that,
making me very tense. What did I do to him?
you didn't do anything to him.
Very good.
He just saw your the way you written the judgment, and he said, oh, there are people like this who are judges of this court. That means I don't get scared, because there's so much of.
That's an issue that we are facing more and more, which is that there are barriers that are created between the court and the litigant. Very unfortunate.
Yes.
And there's no point in talking about things like access to justice unless you're going to make it meaningful.
Yes.
We need to widen the pool of candidates that we pick for judgeships. Now, we're sitting here in a law firm, and there will be in the law firm, I'm guessing, advocates who are actually appearing in court, who are part of the litigation team in a law firm, and who will, over time, by the time they're 48, 49, 50, have acquired a fair amount of litigation experience. They will also, unlike some counsel at the bar, have got enough financial wherewithal to themselves. For some reason, with the recent exception of Mr. Justice Karya, now from SAM, was appointed to the Delhi High Court.
Yes.
We are not even considering this pool.
Yes.
There's an enormous talent pool here. It's a great motivator to people here that they could be considered for judgeship. This is something that we need to rethink now so that you start drawing out the best talent. Why should people become judges? I have no reason to give. I'm not going to tell you about the glamour of the office and the pomp and the ceremony of it, because the work itself is so challenging and so rewarding, and it's probably the best thing you'll do in your life. Certainly it was for me. That's the only reason I can possibly offer. Those 11 years were the best years of my life. And if you asked me, would you do it again? Rewind, rinse and repeat? I would say yes in a heartbeat.
That's wonderful.
Right now.
Yeah.
Except I'm not going back as an ad hoc judge, but still, that door's shut. That's not the point. It's something that was absolutely wonderful for the satisfaction that it gives you. What is the satisfaction? Not an individual case, and though there are lots and lots of individual examples, which would take the rest of the evening, about cases that worked for the individuals who were before you. That's gratifying in itself. Generations of family dispute resolved, something with a flat purchasers getting their flats back resolved, some medical admission pension thing resolved. That works. That's a great sense of satisfaction. Beyond that, it's just knowing that you were able to complete the task efficiently, even in a completely technical matter, involving points of law, corporate law, company law, IBC, reservations law, that you were able to deal with the issue and decide it, constitutional law, and decide it good enough. That's rewarding in itself. That's rewarding in itself.
And is this why you...
No, but the work of a judge is, look, it's not like there's excitement every single minute of it. As I said after I retired in some correspondence with a very dear friend, for the most part, I used to think of myself when I was a judge as one of those electricity transmission towers. You're just sort of basically humming along, doing your thing. And once in a while, there'll be some spark and short circuit and some crackle and buzz, and there'll be a little bit of excitement. Then you'd go back to doing your transmitting electricity, doing something essential.
Yes.
It is essential to society, but just doing this as a job, as a routine, which is really how you've got to see this.
Yeah. I want to underscore one thing that you said, which is the challenge of the work by itself.
Yeah.
And if I would be very happy if you can just elaborate on the challenge, because people need to know how hard judges work.
There are two separate questions. you work only as hard as you want to work. I mean, there is something to be said for breaking it up and keeping it in manageable lots and not letting it affect your health and personal life. And there is another opposite school of thought, which is to say, look at what's before us, take on as much as you can, and dispose of as much of it as you can. It's extremely time consuming. It doesn't give you time for very much else. But what's the difficult part of it? The difficult part of it is that okay, as a lawyer, you are a persuader, you are canvassing one side of it. You have to unlearn this very rapidly in a few days when you become a judge, because you've gone from being a persuader to being a decider, which is
Correct.
that you don't argue with counsel, you ask a question. He or she gives you an answer, then you decide. And you've now got both sides of it. And you've got to navigate between these rival versions of facts and law into something that you believe is a correct reading of the law and a correct appreciation of the fact. That's the difficult part, and it's the beautiful part. That's the problem solving. And that's the endlessly fascinating thing. And a large part of this is you continue to have conversations with yourself as you're doing this, because this keeps rolling in your head. You've got some big matter going on. I wound up keeping pads of paper and pens next to the bed because something would hit you at 2 o'clock in the morning and you had to make a note of it. Otherwise, you'd lost it. So this would then go on for a bit. It was quite difficult, but very rewarding at the same time.
You spoke about problem solving as a judge, and I wonder if I'm coming back to your environmental law practice as an advocate now, and now you're a judge, and let's say Coastal Road project, right? How do you, not you but a judge, okay, maybe not you, manage these twin but opposite requirements of economic development and environmental
A very
protection?
good question. Now, here's the point. You may have been passionate about a cause, forests or environment or whatever. As a lawyer, you cannot carry that forward into judgeship. So, and the forest case is Godrej and Boyce is a case where I was actually as a lawyer on the other side. The Supreme Court pronounced as it did. As a judge, those very same cases or the cases of the same class came back to me. And there was no question of from my position on the bench, re-advocating what I had done as a lawyer. I had to apply the Supreme Court judgment as it stood, which I did. Diametrically opposite to what I had actually argued. But that's the discipline that you have to impose on
Cultivate.
yourself. How do you balance these requirements of so-called balanced development versus environmental protection? Always a difficult ask. Every kind of development is going to involve some form of environmental damage. You've got to balance those two, but you can't let yourself be swayed by your past or the beliefs that you held while you were in practice or as a private citizen, because you're now in public office.
Yeah.
It's a completely different thing.
So are you saying that when you ascend the office, you actually understand exactly what that role means, and then you have to
Yes,
shed
I
off?
do, because I would, for example, not be able to simply combat a project like the coastal road sitting there as a judge by just saying, oh, it's a terrible thing. You would have to listen to what the project proponents have to say,
Yeah.
assess what the benefits are, which is a different matter.
Yes, true. And there's another, I don't know how soon after when you were appointed as a judge, but the whole Bori succession case, right, which was hugely, I'm very curious to know about that entire, from your sort of mind angle, because that was a case that had so many people looking at it. It had so much of emotion. It had all these sentiments, which, how do you, and then I believe you had said something like you have decided on the basis of proof, not religion, or proof, not sentiment. And I remember reading the judgment, I was thinking, oh my God, how difficult would it have been? Because coincidentally at the time I was helping, someone who was connected with professionally helping them. So I was a little bit involved in the trajectory of the case. So I'm very curious to know about how did you manage that? What was, what was going on in your mind?
So 2014, when it first landed on my desk, it came in the form of a motion
Acha.
for interim relief. I didn't see how the motion could be heard without effectively deciding the suit. So I said, let's hurry up and decide the suit. Brave words, but foolish, because nobody anticipated that this was going to be 10 years in the making.
Yes.
And run all the way to 2024.
Yes.
And this was in 2014.
Correct.
And with this pile of witnesses on either side. After that, I let it pretty much run on its own, but it took a lot of management in the sense of managing the witnesses, evidence, marshalling it, making sure that it was all organized and in one place. And then when I found that it wasn't going to travel to other judges, but it was going to stay with me no matter what, that made it a little more difficult later, because by then, towards the end, I was already on a DB. So I had to take time off from the DB to be able to finish this, and there were time constraints involved in that. Plus, paper had multiplied too much, so we had to move to digital. So this whole thing was argued in digital form. In between, we had COVID.
Yeah, so I just want to ask you, when you said the whole thing was argued in digital form, would you...
I had no paper on the desk. So
Okay.
the whole record was digitized, including all the several thousand pages of evidence. We had a sheet which was all hyperlinked, so I could look
So
at
you
this
had
thing.
an iPad, is it?
So I had more than one device. I had the laptop, I had an iPad, I had this, I had that. I mean, that was the only way to do it. Otherwise, I'd spend half my time just lifting files and stuff. This was just much faster and more efficient. We also had quite a speed bump in COVID, because the witnesses at that time were in London
Acha.
and they couldn't be flown into Mumbai because there were these travel restrictions. So we were able to, by consent of parties, set up a system where we had these high-speed lines running from Mumbai to London, advocates at their houses, me in court with my stenographer, a second line running to London so that they could see the transcript as it was being transcribed here. So we got that thing done. Otherwise, we'd never have finished.
Wow.
We'd never have finished.
What did
That
it
was the
take
big
for you to get it done? Like,
the High Court had all the equipment. It wasn't actually very difficult in terms of the tech part of it. You just had to be willing to use it, to be unafraid to use the infrastructure. It was all there. And at the end of the day, you had to look at this not as, no matter how sharply people's opinions or views were divided, and these are matters of faith. So people get very, very
you're very emotionally attached.
correct. But you have to take a long step back from that as a judge, because you have to decide this on the basis of what is or is not proved according to your understanding of the Evidence Act and the standards that are set in the Evidence Act. Now the matter is an appeal, so it will be decided. That's okay.
But
One side's bound to be upset. It's okay.
yeah, but then how did you take that long step back? And because a lot of people, I mean, whoever are our listeners, at some point, hopefully, some of them may become judges, hopefully. I think, and since we are trying to create this historical archive of conversations, I really want, if you can just drill it down a little bit, how did you do that? Especially in such a fraught environment.
It wasn't fraught for me at all.
For you.
It was fraught for them.
For
it
them.
wasn't fraught for me at all. I was keeping it quite distanced. In fact, I told them repeatedly, I don't want you to turn this into some sort of a battle of emotions, because it isn't. It's a battle of proof, and I'm not here to decide whether somebody's faith is right or wrong.
Yeah.
It's not my job.
Correct. Yeah.
I'm nobody to do this.
Correct.
I'm not the arbiter of faith. Every person's faith is as valid to him as it is to everyone else. There's no rightness and wrongness about it. The only question before me is whether the case as pleaded in the plaint is or is not proved in the manner required by law. So you have to marshal the evidence on this. If this is the issue and this is what he has said, how far can one reasonably say, with some degree of confidence, that this is most likely to have happened, or I believe that this is what actually happened. If he succeeds in that, he succeeds. If he doesn't succeed in that, he fails. It's literally, you have to take it like you would every other litigation and in no other way possible. It was a very interesting thing from a different perspective, because if you have any interest in history at all, and this is common to both sides, so it's not controversial, the entire history of the faith is actually quite fascinating. Of Shia Islam is quite fascinating, the whole thing. Well, that's actually quite bits and pieces of this came out in the course of the arguments and the evidence that was there. So that was quite interesting.
Yeah. I'm always fascinated by how much, being a judge and being exposed to the number of issues that come before you, it informs your perspective about life.
Oh, yes. Oh, yes. And not necessarily in a good way. Because when you see what's happening, for example, in the testamentary court, or dealing with family matters, it fills you with despair that there are people in this city who are being oppressed because their children are after their money or after their estates while the parents are still alive, flats, this and that. And some of those cases are very troubling, very difficult. Those ones for medical termination of pregnancy, especially where there's a sexual assault survivor, adoption cases, terrible, terrible. I mean, you do them as best as you can, and then it's horrific in court when you have a family splitting apart over money. It's really.
How do you manage your mental health and all? Like, how do you manage does it affect you personally, or have you learned to, no, not really?
You don't get emotionally invested in any of this. It's difficult because you can't be an effective judge unless you have that one quality, which is empathy. I'm not talking sympathy, it's just empathy. You've got to be able to understand what that person is going through, and you're on both sides of it.
Yeah.
And that's always very difficult. It's always very difficult. And there were 2 or 3 standout moments. I mean, they're not glorious in terms of the law. Some of them there was in fact very little law, but they were extremely gratifying. And one, I remember, there was a man who was now in his advanced years and his business partner, and they'd been fighting a corporate, and it took me 8 or 9 weeks of this to bring the two sides to a settlement. And he wrote me such a lovely letter at the end of it, just saying thank you for getting me to understand that pursuing this wasn't in my interest. And the settlement was less than what he would have otherwise fought for, but it was something that he realized and got in court. And there was another case where there's a family dispute going on for generations, and we now come to, after one set of consent terms, come to contempt and so on.
Oh.
Yeah, so this was going on, and I realized that this was just years and years of accumulated
discord,
anger, angst coming out. And at some point when I went home, and my wife said, "What's happened?" I said, what? She said, "What did you do in court today?" So I said, "A pedicure." So she said, "What?" I said, "That's all I have been doing for the better part of the day, is just scraping away years of dead skin from these people's feet, trying to get them to understand." So we were approaching Dasara that year, and we finally got it done. And the lawyers agreed. We got this thing done. And signed off, and I said, "It's finished." Next day, they're back in court. The day after that is Dasara, so they're back in court. So I looked up, because now I'm just terrified. I said, "This is going to start all over again. I can't do this all over again." I've given them way too much time. So I said, "Why have you come back?" They said, "No, we've only come back to tell you this. And the parties are here because they want to tell you this. That for the first time in God knows how many years, the senior most member of the family has called for a family lunch at the CCI, and 5 generations are getting together after this." So I said, "Well, that's just fantastic."
Yeah.
You've just made my Dasara as well. So that was, it's a great sense when you get that done.
Yeah.
And as I said, there's no law in this.
Yeah.
It's just that one of the things that you're able to do because you have that voice of authority and experience, which is what works. Which is what works. And there were others, some flat purchasers that got stuck, and we were able to do this one project in Bangalore, one here in the suburbs, which was really quite quite gratifying. And one particular case in Goa, I remember when father and his daughter came, name was Poonam, and she was the only girl to have finished school in a remote village.
Oh.
So, an extremely remote, extremely disadvantaged community. Her father and she were ostracized because she went through an education process. And she did her medical exams and she got into Goa Medical College. And only girl from a village to have, that community to have done it. She missed the seat by 1 mark
Oh God.
to another one who was also in a reserved category. Towards the end of the first semester, it turned out that the young lady who had got admission had a fake caste certificate and had abandoned her seat. So there was this empty seat.
Huh.
And here was Poonam and her father saying, give her the seat, this is the only chance she's got. She'll never make it otherwise. And this law from the Supreme Court is clear, for good reason, that you can't keep filling up seats because otherwise people will keep blocking seats by putting in fake candidates and doing this. So it's better to let that seat go vacant. But this was a genuine case. And I'm asking, the lawyers from GMC are telling me all this law, which is correct. So my question is that, look, you're an authority, we're a court. The Constitution binds us both. What is your view of what you're supposed to do for a reserved category candidate? Find ways to help or find ways to obstruct? Because we are quite clear about what we have to do. So my colleague says, Gautam, what are you planning to do? I said, look, there is all this law from the Supreme Court. And if we don't find a way, this child is going to lose the only chance she's got.
That's right.
So she said, I'm with you. So I said, very good, let's go for it. So we said, doesn't matter, but we'll impose a condition. You will not ask for extra benefits, extra time, no allowed to keep terms, no exemptions. If you've lost a semester, you have to make it up on your own. We don't care how you do it. Are you willing? So she was there, her father was there. They said, we are willing. We don't want any exceptions. We don't want any exemptions. We don't want any special favors or treatments. We'll do it. I said, on those terms, all right, done. Petition absolute. Made that absolute. Goa Medical College didn't carry it higher. She got it. 4 years later, she graduates, gold medal, top of her class.
Wow.
Which is, you just, literally you're on the brink there and you'd have to decide whether you're going to just push it over the edge or you're going to pull back.
Yeah.
And it's a risk.
Yeah, it's a risk because
It's a risky business at that time because you're just taking a leap of faith into something
Absolutely.
unknown. Anything could have happened after
Yes,
this.
yes, 100%.
It could have been disastrously wrong.
Yes.
Could have been disastrously wrong. But you have to take that leap of faith
And
and it
especially,
works.
yeah, this is fabulous. Especially when you have a Supreme Court judgment.
Not one.
Multiple. Oh, shoot. So then you're like literally tied, right, from all angles.
You're literally tied there.
So you had to...
But you got to just push it beyond.
Push it beyond. The other part, at least this is what I remember, maybe I'm wrong, but you were always good with technology or early adopter. Early adopter to technology.
Madly fascinated.
Yeah. And
Boys with toys.
So I read something you said, I think in one of the conferences or addresses, I read an article of yours on Bar and Bench, and you had said that India needs to develop a very robust IP dispute resolution mechanism if we want to attract more FDI.
Yes.
So I want to know a little bit about that, your views, what's
Look,
happening.
people think about IP as being this intellectual property, as being this richy rich kind of thing, which is only meant for the
Googles of the
Ricket
world.
Coleman
Yeah.
and Colgate Palmolives and
Yeah.
Hindustan Levers and stuff. It's not like that at all. IP is critical to the survival of the middle and small business. There's a guy who's manufacturing something, an oil, a treatment, a broom, an umbrella. That brand, that logo, for him is a matter of survival. His exports depend on it. His sales depend on it. He doesn't advertise on big billboards, but it's still the brand name that makes the difference. We are only looking at these super brands
Yeah.
for the ultra consumers. There's the average middle class village consumer who knows that by shape, brand, or whatever it is.
Correct.
This could be everything from food products to hardware. IP can't be treated, just cannot be treated as something that's nice to have.
Like a trophy.
It's not a trophy.
Yeah.
In a commercial world, it's a question of survival.
Yeah.
And IP defines of makes or breaks a business, and lots of livelihoods depend on that business. So it's a hugely mixed bag.
But sir, can you just pause a little bit and then drill it down, because and set context as to why is, there may be people who may not understand the context. Why is this IP important? What is
Okay,
IP?
let's say the intellectual property, the brand. Okay, let's take this, break this down. The simplest one is trademarks. A trademark for something like the chairs we're sitting in, they are of a particular shape, but they're made and they have a particular brand. They have a brand value. Now, the manufacturer of this chair may not be a multinational, or may not be a very rich fellow, but his entire business depends on this chair, called whatever it's called, being recognized and having a reputation in the market. His entire factory and workshop and every livelihood, it depends on that business running. If somebody starts imitating, copying, and eroding his brand, that's very serious damage to him.
Correct.
Now, this happens with massage oils sold at Bhendi Bazaar. No. Or somebody who's selling a broom, a particular form of a jhadu.
Yeah.
This makes a difference because it's that average housewife who's going to buy that particular brand
Correct.
of broom or umbrella or chair, which is low cost. Don't look at only the high end IP and think that IP is up there for the rich and for people who can go to Geneva and so on and so forth. It's nothing of the kind. This is really a matter of survival for these people, and you've got to be able to stop the theft of IP. Problem in India is that culturally and historically, we have never learned to respect boundaries. We don't respect boundaries of land. We don't respect boundaries of character, of behavior. This idea that because it's software, therefore it must be free, and what's wrong if I use an illicit false copy is all wrong.
Yeah.
I've forgotten the number of times that people say, oh, these books are just released, and send me these PDFs of the latest publications. Every one of them is copyright theft. Somebody is being deprived of royalty, of money. That's the author's livelihood.
Correct.
Don't do this. If the author wants to give that money, it's no answer to say the author has got enough money. If the author wants to give it away in charity, that's up to the author. You can't steal somebody else's intellectual property rights. There are boundaries.
Correct.
And it is property. All properties have boundaries, and you've learned to respect those. It just can't be done otherwise. This is something we've never understood in this country. And I think that in a city like Mumbai, it's important. We have another problem in Mumbai where just the volume of filings is so high that having dedicated divisions for IP or for commercial are very difficult. Very difficult.
So what do we do?
That's a big question. I don't agree with this theory that many have, including some of my revered seniors, that what's so special about commercial matters. That's the wrong approach. Commercial matters are really the engine that drives not only the economy, but the judicial system. We need to make some changes there. And you can't think of commercial matters as only those big ticket matters involving several hundred or thousands of crores. It's that average man's bank loan or flat purchase agreement, your scooter purchase agreement. These are also commercial matters. any form of hire purchase, these are also commercial matters. You have to look at them and say they are as important. You have to separate them and stop mixing them up with other litigations that are against the government by school teachers for pensions, land acquisition, non-payment of compensation. You should not have to make a choice between should I hear the pensioner or should I hear the person who's selling the flat or who's trying to buy a flat at Dadar.
Correct.
You should not have to make this choice. Both are equally important. You can't possibly legitimately say that the pensioner's case is more important than, for him it's the roof over his head also, no? We have to, but for that we need an expansion of physical infrastructure and bandwidth. You need more courtrooms, more space, more judges, more handling.
Actually, this is one thing that I don't know how we. I think all of us, as part of the profession, should do something. I'm curious to know what you have to say in this, because I was, as you may know, I was an in-house counsel, which means that I am a client to lawyers and a litigant to the court system. And it's very different when you're a litigant and when you're a lawyer.
Correct.
Because you really realize how helpless a litigant is. Completely helpless. Very little control a litigant can exercise over their own dispute after a point. And the amount of judicial delay that is happening, it just completely kills the purpose of, then you settle, then you do whatever. But then you don't leave feeling good. You may feel good in some matters, maybe family, etc. But then when it is a debt recovery, for example, somebody has not paid you. We had a 3 crores arbitration award in our favor. Can't execute. Cannot, because of the judicial. We have to go back to the High Court to execute. And then we settled it during COVID for 32 lakhs. Our books still carry that loss, right? It carried that loss for so many years. So it really has an effect on how people see the country, how people come and do business in our country. I was reporting to a completely international board. They don't want to come and fight disputes in India. In fact, they want to reduce the amount of work they do in India.
This is what exactly my point. That unless you have an effective commercial dispute resolution mechanism through courts with rapid enforcement, you are directly going to affect investment in this country across all sectors.
Yes.
Across all sectors.
Which is why I was very happy.
So sorry to interview the interviewer, but you need to. What would you say is your biggest source of frustration in that experience? Lack of access to justice, is it?
Not lack of access to justice. We don't lack access to justice. It is the judicial delay. I'm already before the court.
So you've already got the access.
I have the access, but I'm not getting the solution. I am there. I have sat in the High Court from morning to afternoon, evening, and not just got FaceTime with the judge when I'm at serial number 7. How do I explain to an international board made up of all non-Indians, Westerners, that this happens?
So what would you ideally like to see? Sorry, we've just flipped this whole show around. Okay?
No, it's good. No, there's a purpose of what would I ideally like. I would like if I have a matter before you, and it's going to come up, it's fixed on 21st of February. I am before Justice Patel on 21st of February. I talk to him, blah, blah, blah. I'm not always, somebody's asking for an adjournment because my senior is on his leg somewhere else. Or, somebody's stuck in the Supreme Court. Or somebody's in arbitration. Have different bars, have a Bombay bar just doing the work in that court.
So you want to, for one suggestion is segregate the work by class.
Segregate the work by work type, I think we need. That's one. And I think few things that I think we are also making a mistake is that I think we are a highly litigious society. We file too many matters. So that is, I think, something that also we need to introspect. But from a process-related angle, why are we not using technology more? You are very aware of this. You're a lot more aware than maybe the average person about the advances, say, in legal tech. I came across a product where you feed in all of your pleadings into the system. It is developed by a lawyer who was a partner with Samvad Partners, 20 years. Beautiful product. It's not a plug or anything. I just like their products. So
Jurisphere?
No, it's called Consensus.
Okay.
I know it's not a plug, but you push everything into the system.
There are 20 people doing this.
Yeah. But anyway, it gives you, summary, everything. You just click and go, and then everyone's anyway using an iPad today. And the judge has it in front of him, and then you ask, okay, parties, why are we reading the pleadings?
I have no idea.
But we do that. I mean,
Correct.
It happens.
You shouldn't have to.
And then what can take 10 minutes now has taken 90 minutes.
Correct.
So I'm saying, can we bring efficiency? I'm not trying to say that I know how hard a judge's work is, but can we get technology to sort of supplement you or support you?
Of course, you must.
Yeah.
Well, it's okay. So here's a bit of a mixed bag. Because I was always have been a bit of a maniacal reader. One of the things from early childhood I've developed is the ability to read very fast and to anticipate what's going where. So if you give me a brief, I'll get through it very rapidly. Others take much longer. And there are others who do it even faster. There are advantages to doing this and getting it done right, which is, the problem is that there's a fear that this is all slanted towards the commercial market, number one. Number two, that, you can't use this for criminal matters when you're deciding bail, which is not what I'm talking about at all. I'm talking about not letting the machine decide the cause, but letting the machine give you, with a certain degree of accuracy, that which your law clerks and interns are doing anyway, which is giving you a summary synopsis of the key areas of dispute to which you as a judge then apply your mind.
Correct.
Which is a different thing entirely. And I think this can be applied to civil criminal jurisprudence both equally, and it can work. So this is something that's worth exploring. Plus, you must have the hardware and must be able to use it efficiently and well, and not treat the computer as a glorified typewriter. That's the problem. You don't have things on an iPad and then start sending stuff back and forth in substandard formats. You have to have more efficient workflows.
Yeah. So how can we all contribute? Like me, and so many others are like us. One of the contributions, like one of the things why I'm very passionate about doing this podcast and getting these conversations on the internet to live forever, is so that we are able to present a realistic picture of what's happening, good, bad, and everything in between. And then maybe prompt other people to say, hey, how can we
I don't know
support?
how you're going to get the judicial system or the powers that run the judicial system to agree to what is a major
Overhaul.
rethink of how they work. Today, almost every law firm is very far ahead in terms of technology that is off the shelf, developed in-house, deployed in-house.
Yes.
And courts generally, rather than trying to figure out how they can adopt and adapt that, prefer to mock it by saying that these law firms are all useless, they're not reading books, they're not... Of course, I still think it's important from perspective to read the books for an understanding, a much broader, wider understanding. But if you have effective tools at your disposal, why court systems should not adopt and adapt them is something that defeats me. If it's more efficient in an increasingly complex and complicated and demanding world, because let's look at it like this. What's the one resource that is extremely limited for a court is time.
Yeah.
What's unlimited is papers and caseload. There's no limit to it. It's just, there's no horizon to it. Now you have to find some way in the finite time that you have to be able to deal with this increasing and ever expanding cloud of caseloads. How are you going to do this? There's no point in talking about pendency. First of all, your definitions of pendency are all wrong. I've been saying this for some time, but nobody is listening. Tell me, according to you, is a petition or a plaint or a suit pending the moment it is filed?
Is it pending before the moment it is filed? If you ask me as a litigant, I would not say it's pending before it's filed.
That's because that's you as a lawyer. The
As a
litigants
litigant
say
is, yeah.
it gets added to the number of cases that are pending, but it's not ready for disposal.
I mean, it's probably
It's not ready
even,
for disposal. And this is doctors, accountants, architects are happy to say that, oh no, it's pending. It should be disposed of on the first hearing. Suppose you're the respondent or the defendant. You don't want to be heard.
Absolutely not.
You don't want
Yeah.
your lawyer to say, listen, give me time
Yes.
and hear me on this.
Yeah.
These are all these non-lawyers who love to say, dispose it off on the first day, as if hearing the other side is immaterial and irrelevant. No case is pending until it is actually brought to a state of readiness for hearing.
Yeah.
None. In any category. Because that's not how a system like this has worked for the last 3,000 years.
Correct.
And it's not going to change because there's some irritated doctor somewhere. Doctors don't have to listen to two views and find what's the correct
What's
view
the problem in the body?
in between. That's the difference.
Yeah.
So those idiotic forwards that you get are best trashed. This whole process is a different process.
Correct.
How is it possible that on the same facts and the same law there are two widely divergent views? That's exactly the beauty and the strength of the legal profession. That's why we have appeals. But when you come to this stage, you add this newly filed case to pendency, your figures get distorted. Take the entire pendency in the judicial system in India and remove those cases that are not ready for disposal and see what that number is. Because they're not ready. They've just been filed. So redefine the word pendency, then we'll have a way to deal with it. If you're muddling this up, you're saying we'll deal with pendency. But these are not cases that are ready. What's the point of saying we'll deal with the 5-year-old case? Is it ready? We'll deal with the 5-year-old case that is ready. If it's not ready, find out why it's not ready. No. That's where AI comes in. That's where AI comes in.
Yeah.
That's where these patterns and flaws AI will detect for you.
Correct.
We've got methods to do this. Our systems and data are in place. The one thing that is lacking in this judiciary, top to bottom, is that nobody is defining a policy based on the results that AI or a query can generate. Nobody.
Is there any way that we can work to help that happen?
Of course. Get yourselves organized. The AI-driven query will identify for you, based on the existing data set, where the problem lies, with a degree of approximation. On that, you've got to frame policies that address this. If a suit filed in the commercial division hasn't had a written statement for 9 months, red flag goes up.
Yeah. Yeah.
Somebody's at fault there.
Yes.
It's either the defendant or it's the court.
Yes.
Fix it. If a suit in the non-commercial, regular suit, hasn't had a written statement in a year, red flag goes up. That data is in the system. That analysis can be pulled.
Correct.
But somebody write the policy based on this. No?
Yeah.
They're not even willing to look at the results of the query, let alone think about write the policy.
And do you think that, people like us,
It requires somebody at the head of policy, head of administration at the state or at the central level.
To actually take this up and actually move through it? Because I'm quite stunned at the amount of, I was probably living under a rock. I did not know the advances in legal tech and all of that. But I was maha impressed with that litigation software and all that. I said, it's made it so much easier for us to go through.
See, in a firm, if you've got contract or you've got pleadings, it's understandable. So let's park that, because it will give you various drafts of your contract. Imagine what it does for a judge who has
Exactly.
a petition, who has a
Correct.
reply, there's a rejoinder, smash it all together, upload it, give me a synopsis.
Yes.
Key points for disposal.
It's wonderful for the judiciary because
Correct.
you're like, out of 50 cases, you have 1 to 50 serially. You're like, oh, okay, 1, 2, 3, 4.
Correct.
You
So,
ask questions and then, probably, again, we come back to the point of workflow. There's one question I have not asked you, which I really want to, which is about your writing style. I did mention a little bit about it. Very funny. I loved the way, and it's like reading a storybook.
That's the idea, no?
Yeah. So tell us a little bit about how do you come up with the way you're presenting the judgments?
Because I think it's an approach to who you're writing for. If you want to write in the classical style, he said, he rejoined, it's boring as hell. These are lives.
Yeah.
There's a story. Tell the story. Tell the story in the most interesting way possible. Something that will grip the reader. Who's the reader? The reader is the litigant.
Yes.
He is not interested in your fancy legal arguments and your fancy legal terminology. Why would you use that? Make it accessible. Make him want to read more. Find out what's happened next. There are various strategies to doing this. Use simpler language.
Yeah.
Make the font readable, which is important. It's a matter of presentation.
Yes.
Keep the narrative clear so that he understands it. Find ways to take the traditional forms and break them. You don't have to say the aforesaid, the said, the this, the that. Identify people. Tell the story as you tell the story. The way you would narrate the whole incident. It lends it immediacy, it makes it more accessible to the reader. And the person has to enjoy reading it also. But it's a lot harder than it seems. It's much easier to do it in that traditional mold.
Yeah. I think you already pressed for time, and then to actually think of presenting it.
Not presenting, also organizing the material.
Yes, of course. Because you want to make it as short as you possibly can while making it
I used to find it incredibly boring to write, let alone edit, when I was doing it in that classic mold about petitioner argued, the respondent said, replied, and then the petitioner rejoined. I was so bored by the end of it that even I didn't want to read what I'd written. I said, if I don't want to read what I've written, how do I expect somebody else to read it? Now, the better way I thought of doing this was to identify the issues that fell for consideration. And under each issue, then set out what the rival arguments are and then set out what your decision is. It's much easier. It's much more readable.
Yeah.
And one follows from the other.
Yeah.
But it's a lot more work.
Yeah, it is. Did you ever have any kind of doubt or self-doubt? Because the way you write the judgment is very radically different from...
Self-doubt about writing? No.
Self-doubt in general? Well,
sometimes in a given case, yes, am I doing the right thing? Is this right? Is this wrong? That, of course, that's bound to happen. Self-doubt about writing style? No, I couldn't have given a damn. Somebody didn't like it, I didn't care.
Okay. And did it bother
What
you?
were they going to do about it?
They'll appeal it.
But they can't appeal against a writing style.
No.
You can't impeach me because you don't like my writing style. All right, you don't like it. What can I do? I'm going to do it again.
But what if they tell you, like, they'll appeal and say, this is not considered ABCD?
I'm going to say, where is it written? And who are you to write the book?
Yeah.
Correct.
Okay.
If you can better this, better it. I mean, that's all.
Yeah.
I was never bothered about writing style. I used to do it.
And the one more topic that I want to talk about is you teach and mentor law students, and you've been doing it even before.
I think that's very important.
Yeah, that's something. Can you talk a little bit about that?
See, I'll tell you. I think it's. Okay, so I'm going to go out on a limb like this. I think honestly, it's a colossal failure of an individual who has been through the system, succeeded, not to find some way of paying it forward. This profession has given us everything.
Yeah.
It's all very well. I can sit around and say, I've got arbitrations, I've got opinions. And I'm hiding in my little closet and I'm doing this. But unless you are passing this on, you are doing a disservice to everything that you have gained and everything that the profession has given you. It doesn't matter what quality of teaching, you have to step up to the plate and volunteer, because there is a crowd of people here who are dying for you to volunteer to come and teach.
Yeah.
And they're afraid to ask sometimes.
Yes, yes, of course.
If you just volunteer, they'll just say, yes, yes, please come, please do.
Yeah.
And I think I'm going to say this, I think it's irresponsible not to do it. It's utterly irresponsible not to do it. What do we gain from it? Money? None. Loss of time? Colossal. Because preparing for these lectures takes an incredible amount of time. What happens at the end of it? You have a student who says, I remember your lecture from 5 years ago and I've understood the concept and I'm carrying it with me forward in the legal profession. Guess what? Not only is he better for it, but the legal profession is better for
Correct.
it.
And his clients, we are at the end of the day.
That's the idea.
We are guardians of people's lives and
That's
business.
right. No, you absolutely have to give it back.
Yeah.
Then you have to make the time and the space for this.
And it needn't only be people as senior as you. Maybe
No,
all
it doesn't
of us.
matter.
Yeah.
It doesn't matter at whatever level, but you absolutely have to start doing this.
Yeah.
You absolutely have to start doing this.
Correct. I agree. I hope we're all doing a little bit.
It doesn't matter at what scale you're
Yeah.
doing it, but you have to make it has to be structured. You can't say they're in my office and we had this discussion, therefore my teaching job is done. No. No. It has to be structured. You got to say, whether in a firm like this, you say that, okay, 1 day a week or 1 day every 2 weeks, we're going to take an afternoon or 2 hours off and study, and somebody is going to present and teach this aspect of the law. It just has to be done.
So it needn't be
No,
like
it
going to
needn't
a
be.
college or...
No. And those who've retired from this, I think they have to engage. They must engage.
So on this note, this main part of the conversation is done, but there's one last part of the conversation which I do for myself because I love hearing the answers. And that is, we call that 5, 4, 3, 2, 1. So where they are shorter answers. It's like a rapid fire, but then it's called 5, 4, 3, 2, 1. So I ask you 5 of something, 4 of something, 3 of something, like that. So 5 productivity tips that you'd like to give. You can give apps or whatever if you use.
My one productivity tip, get on with it.
Yeah. Yes.
Just get on with it.
Yes.
Stop reading about productivity tips and
Do it.
Just be productive here.
Okay.
Simple.
Yeah.
You spend more time reading about those tips than actually doing the stuff.
Doing the tips. You like this, Sana? 4 books that you recommend anyone should read.
Law or not law?
No, not law. Not law. You can give anything. Any books, 4 of your favorite books or whatever, that you would recommend people should read.
Well, let me tell you, if you are at all interested in legal writing, there are 2 books by an American writer. They're expensive. They're on Amazon. Kindle version also. By Ross Guberman, called Point Made and Point Taken. About how to structure concise briefs from very complex facts.
Wow.
You have to do this. And he takes the judgments from US, Canadian, English courts and shows you how in a compact manner, in 5 lines,
Wow.
they've got the point of the case across. And you use these as study texts because you look at them and then you understand what has been achieved. Chief Justice John Roberts of the United States Supreme Court, for example. And you ask yourself, wow, this is great, this is compact. Can I do better? Make it even more compact. You find that your writing style just goes straight up through the roof because you're really paying attention to being compact. And you can follow a series of lectures by Brian Garner, the editor of Black's Law Dictionary and so on just writing styles, which is really worth doing. It's really worth pursuing this. And that's one of those great teaching books. And the other book that I recommend to every law student I come across, which is out of print, but I've spoken to the family, hopefully we'll get it back, is that incredible little book by Atul Setalvad called Introduction to Law. Across a range of subjects, it gives you the fundamental principles. It's your stepping stone into law. It's really that good. And it survived time. I really hope they'll be able to put it back into print because it doesn't matter if this SEBI regulation has changed or that SEBI regulation or these new criminal acts have come. The fundamentals are in that book. It's just a great Bible for a student to have through the first, second, third years of a law course.
I
That's
guess
fantastic.
all of us.
Yeah. Anyway.
Okay, 3 lessons that you want
For what?
young lawyers to learn.
What
Like,
young lawyers
what do you
learn?
want to, yeah, for young lawyers or law students, what do you want to tell them? 3 things. Any 3 things.
Don't be afraid of judges. In 150 years of the High Court, no judges climbed down and slapped a lawyer, so it doesn't matter. Stand your ground.
Seriously?
Don't take yourself too seriously. Don't take your senior at all seriously.
Oh boy.
Keep a sense of humor.
That's
right.
That we can
That
see.
is right. These are the 3 tips.
2 life lessons that you learned.
Comfortable shoes is life lesson number
It's
1.
good, yeah. It's a good
Life
one.
lesson.
Yeah.
Very important.
Yeah, I agree.
And always in your court and you're wearing a jacket, make sure it's 1 size larger than you need.
Okay.
A very important life
Yeah.
lesson.
And the last one is the best piece of advice you've received.
Treat your criticisms and failures with as much indifference as your successes, and vice versa. Both are ultimately irrelevant.
True.
Irrelevant.
On this note, I think this is a great note to end the podcast. Thank you so much
Most welcome.
for this. We had such
We had
a
a lot of
wonderful
fun.
time.
Thanks.
Thank you. Thank you.
Thanks a lot.